Perfect.
Perfect. Can everyone hear me?
Yes.
That's great.
I'd like to introduce, I would say, a friend of mine and someone I've known for a long time and has been quite influential on me as a Canadian transportation lawyer, and that is Israel Ludwig. And so Israel is with one of our sponsors, PFK Lawyers. Thank you very much. And one of the things that I could say is that Israel, of course, is our past president of the CTLA and was quite an influential and dynamic president at his time. And he had the CTLA conference in Winnipeg, which is excellent because it means that we have another province and more diversity again in the West with different clients and a different approach to the bar. But one of the things I'd like to say is that although Israel was a great president, I have to say, Israel, that I think that in your role as past president, perhaps you've brought even more to the association in Canada. Some of the things that Israel has done for us that I really think have added to the value and contributed to our success is that as our past president, Israel holds a role, I beg your pardon, my battery is low. He holds a role where he works with our counterpart, the Transportation Lawyers Association. That association out of the United States is a larger association with approximately 1,100 members. The significance, though, of what Israel has done is when he is appointed as our CTLA representative to TLA, as opposed to how it used to be from what I could see in the past, where you would get to go and swan around a beautiful hotel, eating and drinking food, and then showing up and giving an update about what's happening in Canada. We actually had to ask Israel to use his aplomb and his diplomacy and his fine lawyering skills to present some unfortunate changes that we'd had at CTLA as a result of having lower, we had financial restraints. And so then on at least 2 occasions, Israel attended at the executive committee, one a private executive committee meeting with the TLA, another one that was open where I had the benefit to actually hear Israel speak on our behalf. And I just wanted to make clear that Israel, you achieved a lot for us. You achieved a lot in maintaining our international friendships with the American TLA. You advocated for us, and you really made gave a chance to shine a light on our culture in a pandemic, and you made us stronger. So in that context, you're a great lawyer. You've gone all the way up to the Supreme Court of Canada. You've delivered Justice Laskin for us on a panel, and you really strengthened our relationship and kept us on solid ground. So it means a lot to me, and I'm so glad that I got a chance to introduce you. I can't wait to hear your panel.
If any of you see that you think there might be some coloring problems with the screen, it's just making me blush. Okay, I want to introduce my panel. And first, I just want to talk just briefly about the topic. Last December 2019, the Supreme Court of Canada came down with a decision known as Vavilov. And it was one of a trilogy, 3 cases that were heard together in the court at the time the cases were filed, had asked counsel to deliver argument as to whether or not there should be a change as to how courts do judicial reviews, particularly of non-judicial tribunals. That resulted in this decision coming down, which in my opinion has made major changes as to the way we handle judicial review tribunals. And I bring before you 3 people that I think are very qualified to talk about this matter. And if I may, I'll start with the Honorable Justice John B. Laskin, not to be accused with John I. Laskin. And Justice Laskin is with the Federal Court of Appeal. He hails from Thunder Bay, Ontario, and grew up there. In fact, his father was the mayor of Thunder Bay for a number of years. Also, John's uncle, Bora Laskin, was former Chief Justice of Canada. But John has been no slouch himself. He's practiced litigation for more than 30 years in the Toronto office of Torres LLP. He's been, of course, as counsel into all the different levels of court we have here in Canada. He's a fellow of the American College of Trial Lawyers and of Litigation Council of America. Has been a member of the Ontario Regional Committee of the Supreme Court Advocacy Institute. He has spoken, written, and taught frequently on matters of public law and advocacy, and was co-editor of the Canadian Charter of Rights Annotated. Before entering private practice, he was a professor at the University of Toronto as Faculty of Law. He graduated from York University with distinction as a BA, got an LLB and a gold medalist from the University of Toronto, and an LLM from the University of California, Berkeley. He's past president of the University of Toronto Law Alumni Association and was actively involved in the founding of the Faculty of Law at the Lakehead University, and that his courses in Thunder Bay. In 2015, he was awarded the Law Society of Ontario's Law Society Medal, given for outstanding service within the legal profession, with the services in accordance with the highest ideals of the profession. Justice Laskin was appointed a judge of the Federal Court of Appeal in June 21st of 2017. Hope I've covered enough about you, Justice Laskin.
Too much, thank you.
Okay, we also have Brandon Kane. Brandon Kane is a partner at McCarthy's and was one of the lead counsel that argued the case on behalf of the National Football League and Bell Canada, which was one of the other cases of the trilogy that was being argued before the Supreme Court that day. Brandon Kane's practice focuses on appellate litigation, administrative law, broadcasting and telecommunications, commercial disputes, class actions, and product liability. He's active for a wide variety of clients in major litigation and has appeared before the Supreme Court of Canada, the federal, Alberta, British Columbia, Manitoba, Ontario, and Saskatchewan courts. Brandon is the co-founder of the National Appellate Litigation Group and has acted in many appeals, 20 appeals in the Supreme Court of Canada. 8 of his appeals are included in Lexpert Magazine's annual list as the top 10 business decisions in Canada, with 3 ranked as #1. Very impressive, Brandon. 2 others have been named a National Impact Case of the Year by the Benchmark Litigation Canada. As I said, he argued on behalf of Bell Canada and the National Football League with respect to the case before the Supreme Court of Canada. He's an active member of Canada's legal, academic, and professional communities, an adjunct professor at the University of Toronto and Western University faculties of law, and has authored or co-authored 20 articles in a variety of legal publications, many of which have been cited by the Supreme Court of Canada and other Canadian courts. Called to the Ontario Bar in 2004 after receiving his LLB honors from the University of Toronto in 2003, his MA in philosophy from the University of Toronto in 1999, and a BA first class honors in philosophy from Queen's University in 1998. Brandon, pleasure having you here.
Thank you for that introduction, Ralph.
James Holton is the 3rd person on the panel. We affectionately know him as Jamie. He's an associate at McCarthy's. Jamie's practice involves administrative law and matters in federally regulated sectors, as well as the complex intellectual property litigation, including patent, trademark, and copyright disputes. Jamie acted on behalf of the appellants, Bell Canada and National Football League and the Supreme Court of Canada, and helped develop the argument, which was eventually successful with the Supreme Court. Jamie has considerable appellate trial and injunction experience, appearing as counsel in the Federal Court of Appeal, Federal Court of Appeal for Ontario, Ontario Superior Court of Justice. He's acted on behalf of international pharmaceutical and biotechnological companies, telecommunication companies, sportswear and technology companies, finance services providers, trade unions, individuals, and small businesses. Before joining McCarthy's, Jamie served as law clerk to the Honorable Justice David Stratus of the Federal Court of Appeal and assisted in deliberations on cases in the areas of administration law, including statutory appeals, IP, tax law, and civil procedure, and practice in administrative law and IP litigation at a litigation boutique. What Jamie's bio here doesn't show, and I think we should reveal it, is that Jamie, before he went into law, was a professional racer of Formula 4 racing cars and drove for the Ford Motor Company and was successful and won many races in Grand Prix across North America. very wisely got out of it. So those of you that may have a question of Jamie about how you switch gears without using a clutch, just put it in the chat box and we'll see if we can get to it. Now,
Thank you, Ralph.
I believe, Justice Laskin, that you have a caveat you want to state about this presentation today.
Oh, thanks, Ralph. Just a couple of things. Well, first, thank you again for the introduction, and thank you to the group for inviting me to join in this panel. I appreciate the opportunity to speak with some users of our court. The one thing I wanted to mention, and I know you'll appreciate, this is not a Senate confirmation hearing, I know, but there will be limits on what I can say as a sitting judge on certain of the things we discussed. So I hope you'll keep that in mind.
Thank you. What we'll do is there's a series of slides that are going to be shown. Jamie, have you arranged for those slides to be to come up as people speak?
Yeah, I have those here, Rail. I'll just share my screen, and hopefully everybody can see this now.
Oh, perfect. Yeah.
Can everyone see that? Does that look good?
Yeah.
Okay, perfect. So we've already gone through this slide. We'll move to the second.
Okay. So Brandon, why don't you start? What I'm going to ask the people that are listening is, if you have questions, put them in the chat box. I'm going to try and have this presentation finished with enough time for us to review the questions and provide answers. So Brandon, it's all yours.
Thanks, Rail. So we thought it would be helpful if we begin just by providing some basic background on administrative law principles and the standards of review and how they're applied by Canadian courts. You know, particularly for those lawyers who may be joining us from outside Canada. Standards of review are really legal thresholds that courts apply in reviewing decisions of administrative tribunals or lower courts, whether on an appeal or a judicial review application. And depending on the standard that the court applies, the threshold that needs to be met when you're challenging a decision can either be easier or more difficult to meet. So if the standard is correctness, for instance, a court can set aside a lower decision so long as the court disagrees with the outcome in it. And so correctness is the easiest standard of review to meet if you're challenging a decision. If, on the other hand, for instance, the standard is reasonableness, then the threshold is more difficult to meet. And in that case, the court can't set aside the lower decision just because it disagrees with the outcome in it. Instead, it has to show what is really called deference to the lower decision maker. And it can only set the decision aside if it identifies a more fundamental defect in the reasoning, such that it can conclude that the decision is not just incorrect, but unreasonable, which is a higher, more difficult threshold to meet than simply showing the decision is incorrect. So the basic function that standards of review perform in the legal system is to help courts decide how much, if any, deference they should be providing to lower courts or administrative tribunals when they're reviewing their decisions. And this sounds at first glance like it's a fairly straightforward concept, but there's actually multiple layers of complexity to it. And one of the things that makes it complicated is that the standards of review that apply can differ depending on the type of context that one finds oneself within. And in this respect, it's important to bear in mind that the reasons why courts do or do not defer to lower courts or lower tribunals are not always the same. So when you're dealing with, when an appellate court is dealing with a decision of a lower court as opposed to an administrative tribunal, the main reasons for deference are primarily, you know, there are judicial efficiency reasons, for example, that courts want to limit the number and length of appeals. They also want to promote the autonomy of the trial process. And they recognize that judges are ultimately, the trial judge is better suited to make findings of fact because they're closer to the evidence. And so what this ultimately means is that on an appeal, a court is going to show significant deference to a trial court's findings of fact. But it's not going to do the same thing on a trial court's findings of law, because the whole function of appellate courts is really to articulate legal rules and ensure that they're applied in a consistent fashion. So that just sort of translates into, lots of deference on factual issues and not a lot on legal issues. When a court is reviewing a decision of an administrative tribunal, the main reasons for deference are a bit different. And they really flow from the fact that an administrative tribunal is given a statutory mandate by Parliament or a provincial legislature to decide a particular issue. And because of that, there's a very strong presumption, absent some indication in the legislation itself that gives that tribunal its authority, or because of some concern relating to the rule of law, that those tribunals were intended to and should actually receive deference. And unlike the standards of review that apply to lower courts, those that apply to administrative tribunals ultimately are rooted in concerns of constitutional law, which Jamie is going to address now. Jamie, over to you.
Thanks, Brandon. I'll move to the next slide. Perfect. So I think the first thing to note about judicial review in Canada anyway is that it's a constitutional guarantee. And the definitive statement of that really stems from a 1981 decision of our Supreme Court called Crevier, and that was decided by Justice Boralaskin at the time. And in Crevier, really the court had to grapple with a piece of legislation that tried to insulate a tribunal from review by a court. And ultimately what the court said is that's not a constitutional piece of legislation. You're not allowed to oust the role of the court in reviewing these kinds of decisions. And the real motivation for that was something called the rule of law concern. And so even though the judicial review is constitutionally guaranteed, that doesn't really help to determine how to conduct judicial review. So for that, we need to look to some judge-made law. And what the cases say is that the courts are really intending to balance two concerns, two constitutional concerns. The first is the rule of law concern that Brandon mentioned, and then the second is this idea of legislative supremacy. And what the rule of law concern requires is that the administrative decision maker acts within the boundaries of the authority that were given to them in the legislation. And the second concern, the legislative supremacy, requires that courts, like everybody, obey the validly enacted legislation. And in the case of administrative law, that validly enacted legislation granted the decision-making authority to an administrator, not the courts. And so what this creates is a tension between the rule of law concern on the one hand and the legislative supremacy on the other. So for instance, we could say that the rule of law concern requires administrators to correctly construe a statute or a piece of legislation in exactly the same way that a court would, but doing that would really overpower the legislative supremacy concern, which effectively empowered the tribunal to make the decision, including about how their legislation should be interpreted. So on the other hand, if you were to give complete control to the administrator, what that would effectively do is allow the administrative tribunal to make decisions that came outside, that exceeded the boundaries of the grant of authority in the legislation. So in order to strike that right balance between those two concerns, rule of law and legislative supremacy, there are a variety of cases, including Dunsmuir and some that we'll speak about, that introduce this concept of the standard of review. And what that is supposed to do in the administrative context is calibrate how deferential a court is supposed to be when reviewing an administrative decision. And over time, the courts have articulated a variety of different ways of doing this. In Crevier, it was a jurisdictional approach. Then later, there was a contextual, pragmatic, and functional approach that was introduced in a case called Bibot. There were the creation of new standards of review, including one called reasonableness simpliciter. That was in a case called Southam. And then there were attempts to roll jurisdiction analysis from Crevier into the correctness review. That was Pushpanathan. A merger of the two standards and the creation of presumptions that were supposed to help guide courts in determining what standard applied. and ultimately the Vavilov case that we'll be speaking about today, which really cements the idea of presumptions. So with that, I'll turn it back to Brandon to describe the Dunsmuir line of cases and how we got to Vavilov.
Thanks, Jamie. So as Jamie kind of pointed out, the history of administrative law in Canada is really a history of competing judicial perceptions of these two major principles, one being legislative supremacy and the other being the rule of law. And at different times in Canadian legal history, different courts, the Supreme Court in particular, have attributed different weight to these principles. So over time, the courts initially attributed a lot of weight to the rule of law principle. And what that meant was that courts were particularly willing to intervene in overturning tribunal decisions and calling them, instances of jurisdictional error. And as time went on, that approach came to be less in favor, and courts started giving more effect to the legislative supremacy principle. And that meant that they started to take a more contextual approach to assessing what the standard review should be and looking at a number of different factors. The problem with this trend in the jurisprudence was that it created a lot of uncertainty. The more courts were looking at a whole bunch of contextual factors to determine what the standards of review were, and the more flexible they were in formulating the different types of standards of review. Jamie mentioned that they expanded it to 3 at one point. The more difficult it was for litigants ex ante to understand what standard may be applied, and for courts asked to apply a standard to figure out which one they were going to select. So in an effort to resolve these concerns, the Supreme Court of Canada in a 2008 case called Dunsmuir tried to simplify the process by doing a couple of different things. And first thing it did was it eliminated one of the 3 standards of review, the standard of review being patent unreasonableness. It just said after Dunsmuir, there's only 2 standards of review, it's just correctness or reasonableness. The second thing it tried to do was to, take this contextual approach to determining the standard of review and put it on the back burner, and in its place, in large part, establish a series of presumptions and categories that would really allow courts to, not totally at a glance, but give them a much better ability to, determine what the standard of review would be without having to engage in a very involved analysis. So we ended up with things like there were presumptions of reasonableness based on certain features of the case. For example, if the case involved a question of fact, policy, or discretion, if there was a statutory privative clause, which is a provision in legislation that limits the ability of courts to review a decision, the fact that the tribunal was interpreting its own enabling home statute was something that gave rise to a presumption of reasonableness. And importantly, for what we're going to talk about today, the fact that the tribunal had expertise in relation to the subject matter was also something that would, give rise to a presumption of reasonableness. On the other hand, the court said, look, there are certain categories of questions, like constitutional law questions, questions of what it called true jurisdiction, those of central importance to the legal system, or those involving competing jurisdictional lines between 2 or more tribunals, that basically it said if you fall within one of those categories, then the standard of review is going to be correctness. And then it said, and if this approach of presumptions and categories doesn't yield a clear answer to what the standard of review is, then you can always fall back on what was, the approach that applied up to that point, which was a contextual analysis where you would look at a series of different factors depending on, what was at play in the legislation and the nature of the regime to identify what the standard of review would be. And so this was the approach in Dunsmuir, and the problem was it ended up not really creating much more certainty than what it tried to replace. It didn't really explain very clearly what the relationships were between the presumptions of reasonableness on the one hand and the categories of correctness on the other. If you fell within both simultaneously, there wasn't really a mechanism to resolve that. And the continued existence of this contextual analysis for determining the standard of review promoted the same kind of uncertainty that the Supreme Court was trying to get away with and get away from in Dunsmuir. So it wasn't a very good solution. So over the next, and I think we want to move to the next slide, Jamie, unless there's, over the next 10 years or so, the Supreme Court started to retool its approach, in part because it recognized that the Dunsmuir framework was not promoting the greater simplicity that it had, sought to achieve. It started to move further away from a contextual approach to determining what the standard of review should be, to one that involved a very strong presumption of reasonableness whenever, particularly for questions of law, whenever a tribunal was interpreting their home statute. And the problem with this was that it did create more certainty, because we knew whenever we were dealing with a tribunal's interpretation of its own statute that the standard would be reasonableness. But it really didn't give effect to indications in the statute itself that Parliament or the legislature didn't intend there to be deference, particularly for things like the fact that Parliament included a statutory appeal right that basically said, listen, we think that there's an issue here that you're allowed to take up to a court, and a court can review that. That's sort of a signal by Parliament or the legislature that it doesn't really intend that issue to be one on which courts defer. Because of that, in 2018, the Supreme Court granted leave to appeal in the two cases that Rael mentioned earlier. Well, the three cases, Vavilov and then Bell and the NFL, which was actually a joint appeal where they issued a single set of reasons. And this was really done to clarify and revise the framework that had been set out in Dunsmuir. And I'll just very briefly describe the facts and then ask Justice Laskin to discuss really the basic holdings in terms of what they did for reasonableness review. The two cases both arose on appeal from the Federal Court of Appeal, but the resemblance really ended there. So one, the Vavilov case was a judicial review of a decision of the Canadian Registrar of Citizenship, and it involved a very set of interesting facts, whether a child born in Canada to covert undercover Russian spies was a Canadian citizen, or whether he was precluded from being a Canadian citizen because there was a provision in the Citizenship Act that basically said, if you are the child of a diplomatic or consular official or other representative or employee in Canada of a foreign government, then even if you're born within Canada, you can't be a citizen. The second appeal, the second set of two appeals, the conjoined appeals, Bell and NFL, they were a statutory appeal. They weren't a judicial review, which is a different mechanism for actually bringing an administrative decision up for review before a higher court. They were a statutory appeal from a decision of the Canadian Radio, Television and Telecommunications Commission, which we call the CRTC, that involved a practice known as simultaneous substitution. And I'll try to explain very briefly what simultaneous substitution is. It's a little complicated. It was a practice that was enshrined in CRTC regulations that allowed a Canadian television station, if that television station went out and purchased exclusive rights to distribute, to broadcast a particular American television program, like for example the Oscars, that television station could go around to any Canadian cable or satellite company that was distributing US versions of that same program and say, you have to take my Canadian version and essentially substitute it over top of the American version. And this was done to ensure the Canadian television station captured the entire Canadian audience market, so that it was able to then sell that advertising space to Canadian advertisers without it being splintered. What the CRTC did in this decision was it basically said for one particular program, the Super Bowl, this regime is no longer allowed to operate. So that was the backdrop to the trilogy, the administrative law trilogy.
Justice Laskin?
Over to me. So what did the Supreme Court do in this trilogy? On the slide, you have the essence of what the Supreme Court did. It revised the framework that had been applied in Dunsmuir. And it really reinforced the presumption that reasonableness is the standard that applies, subject to only limited exceptions, whenever a court reviews administrative decisions of any kind. And it did so. The driving factors were the ones to which Jamie has already referred. It's an attempt at a balance or a resolution of the tension between the legislature's decision that certain kinds of decisions will be made by administrative agencies and not by courts. And the other factor that's balanced is the constitutional role of judicial review, to which my colleagues on the panel have already referred. And this is the approach that the court said should apply to every kind of administrative decision. And we'll talk about what reasonableness means in a few minutes. But let me first just give an indication of the limits on reasonableness. Where does reasonableness not apply? There was a limited number of exceptions that the Vavilov case contemplates, some based on giving respect for the intention of Parliament or the legislatures, and others based on concerns, again, about the rule of law, which are pervasive in this area. So what are the exceptions to reasonableness review? One set of exceptions applies where the legislature itself has specified what kind of review should be undertaken. And there are statutes in various jurisdictions in Canada that contain that kind of specification. The most explicit, perhaps, is the BC Administrative Tribunals Act, which goes so far as to specify reasonableness or patent unreasonableness as governing standards, and to define what those terms mean. A second category of exceptions, to which Brandon has already referred, consists of cases in which there is a statutory right of appeal, and Parliament therefore intended that these decisions should be reviewed just as normal as occurs in appeals in other contexts. And then the rule of law exceptions are three, at least for now. First, constitutional questions, which the rule of law requires be answered correctly. Those are decisions, therefore, where the courts have the last word and not the administrative tribunals. Second, a category comprising something called general questions of law of central importance to the legal system as a whole. And this is a bit of a carryover from Dunsmuir, where Dunsmuir said this kind of question is subject to correctness as long as, is not subject to reasonableness. And the third is questions regarding the jurisdictional boundaries between administrative bodies. If there's, on the face of it, you don't know whether one administrative tribunal or another was mandated by Parliament to make this decision. But the clear message from Vavilov is that reasonableness is the presumptive standard, and that the exceptions, while not exhaustively spelled out in Vavilov, are very limited indeed. The court held out the possibility that there might be further exceptions, but we can see a real reluctance to create them in the reasons of the court.
Thank you. Jamie?
Yeah, just before we leave this slide, I just want to touch on the last bullet at the bottom of the page for some of our American colleagues who may be on the Zoom. In Canada, the analysis proceeds a little bit differently than it does in the US. And by that I mean that at the outset of the judicial review exercise, the Canadian courts don't really draw the same kinds of distinctions that the US courts do. They don't engage in the same kind of categorization exercise in order to determine the appropriate standard of review. And by that I mean the degree of deference that might apply to the particular interpretation. So the prime example, I think, of this would be in Chevron, the leading case on when a tribunal has interpreted some piece of statutory legislation. And really, in that case, the court defers to the agency's interpretation if the statute is ambiguous and the agency's interpretation is determined to be reasonable. There's also something called Skidmore deference, where deference is really only afforded proportional to the degree of the justification that the tribunal gives for the interpretation that it's offered in its reasons. But what's present at the outset of these analyses is an effort to really categorize the kind of question that's being reviewed, which is different from the way Canadian courts approach the issue. Canadian courts would say Vavilov applies to all of these decisions, and then the question is whether the decision is reasonable or not, whether or not it's one that deals with fact or law, pure law, mixed fact and law, or what have you, subject to the exceptions to the correct. Go to the next slide.
We should change the slide. Justice Laskin?
Right, I've touched on some of these exceptions already, but let me just elaborate a little bit on one or two of them. I've talked about statute specified standards of review, as in the British Columbia legislation. Talked about statutory right of appeal, and that's, and we see that in the Canada Transportation Act, for example. Constitutional questions, that's probably self-evident. The category of general questions of law of central importance to the legal system as a whole, that category can be difficult. There was, as I mentioned a minute ago, a similar exception in the Dunsmuir framework. And there had been a great many attempts to characterize legal issues as questions of law of central importance to the legal system as a whole. But in very few cases were legal issues recognized as having that characteristic. One example would be solicitor-client privilege. That's obviously of general importance and was found to be of general importance. Parliamentary privilege was another one in that category. But many, many attempts to characterize decisions or issues as of central importance to the legal system as a whole failed on the basis that they were really not the kind of issue that was truly of central importance to the legal system. They may be of importance in a particular context or important to a particular individual, but they didn't go beyond that. And certainly in our court, we have been taken cue from the Supreme Court, and we have not recognized many questions of law as coming within that category. We see litigants continuing to make these arguments. Just recently, for example, it was argued before us that the question of the circumstances in which a party can waive statutory entitlements to benefits, that was a question of central importance to the legal system. And we concluded that that didn't make the threshold. So that's one to keep an eye on, but it's unlikely to be interpreted in an expansive manner. Excuse me.
Jamie, I think we'll go to slide 7 now.
Great. So one of the big shifts really in Vavilov, at least in my view, was a renewed focus on the reasons actually offered by the tribunal for its decision. And what the Supreme Court really emphasized was that reasonableness review has to focus on both the outcome and on the reasons that were offered for it. So both what the tribunal decided and the reasons that were offered in support of that decision. And while that sounds like it should be trite, it's really not. And in reality, it's really a return to the importance of the reasons, which had been de-emphasized in a series of decisions that began most notably, I think, in the Newfoundland nurses decision of the Supreme Court. That was a 2011 decision, and a whole host of cases that followed it. And what those decisions really emphasize, and Newfoundland Nurses, I think, being the first true example of it, was that courts should focus not really on the reasons that were given in support of the decision, but on whether the outcome itself was reasonable. And where the outcome itself was reasonable, courts could fashion their own reasons in support in order to uphold the tribunal's decision. And that decision was really picked up on by a lot of courts, I think, including the federal courts, who essentially, they analogized it to connecting dots on the page. And they said, where you can connect the dots on the page, the decision is reasonable and therefore ought to stand. Now I would say, following Vavilov, that kind of reasoning probably is no longer permissible. You really have to focus now both on the reasons that were given and on the outcome. And over the slide on the next page are the court's real rationales for that, or at least their holdings. These are the two key paragraphs. And I won't read them, but the underlined portions, I think, really re-emphasize the importance of the reasons. In the first instance, it's not enough for the outcome of the decision to be justifiable. An otherwise reasonable outcome cannot stand if it was reached on an improper basis. And then in the last paragraph at the bottom of the page, it's not appropriate for a reviewing court to fashion its own reasons in order to buttress the decision. It's not appropriate to disregard a flawed basis for the decision in order to justify the outcome. And in my view, at least, that is a positive development, I think, for a couple of reasons. I think first, it was problematic to assume that a decision maker would make the same decision after it had been pointed out that the reasoning that it had relied on was problematic. So I don't think you can make that assumption necessarily. And then the second real reason is that all of the Supreme Court's decisions have focused on three requirements for a reasonable decision: transparency, intelligibility, and justification. And really what the Newfoundland Nurses line of cases did, I think, was kind of neglect those three standards for reasonableness. And now that we focus on the reasons again, I think there's a return to the emphasis on transparency, intelligibility, and justification.
So we have the next slide, Justice Laskin.
So just jumping off from where Jamie left off, again, what does it mean that a decision is reasonable? On the other hand, when will a decision be regarded as having been reached on an improper basis, to use the words that the Supreme Court used? Reasonable decisions have to be, as the slide says, internally coherent and rational. And the outcome must be justified in relation to the facts and the law. And here we have the court introducing what it refers to as constraints that the decision maker must keep in mind. And this slide lists a number of those constraints. They are both legal and factual constraints that will bound a reasonable decision. The legislation itself under which the decision is made will be important. The reasons must show that the decision is consistent with any limiting language. Statutory interpretation will be brought into play, and the interpretation of the governing law will play a big role in determining whether a decision is reasonable, because there's a rational chain of analysis. International law may, depending on the circumstances, have a bearing. The record may come into play. Do the facts before the tribunal, are they reflected in the decision the tribunal made? So can we say that the tribunal decision is within that constraint? The submissions of the parties, which is probably a pretty obvious factor. Administrative precedents and the impact of the decision on the individual. The more severe the impact, the more the court has to justify, the decision maker has to justify the decision that it made and show that it's justified through its reasons. I want to spend a minute on administrative precedence because this is a factor that can potentially loom large. Our court just released this week, in fact, a decision that I wrote analyzing an argument based on administrative precedence. The Supreme Court suggests that one constraint on an administrative decision maker is that like cases should be decided alike. And if a case is like other cases decided by the tribunal, then it has to justify not deciding the issue the same way. Now, this isn't quite the stare decisis, the doctrine of precedent that binds courts, but it does potentially at least limit the freedom of action of an administrative tribunal, or at a minimum requires it to explain why it decided the way it did. And there's a similar constraint referred to in the decision, and that is if the decision departs from the regular practice of the tribunal in deciding cases, then too, the tribunal, the administrative decision maker, has an obligation to explain why it is changing its approach to an issue. So I think we can expect counsel going forward to focus their submissions heavily on these constraints, to try to demonstrate that at least counsel seeking to attack administrative decisions will try to demonstrate that the tribunal has not paid sufficient attention to these constraints. And to the contrary, those seeking to uphold the decision will frame their submissions in terms of these constraints and attempt to show that the tribunal has explained the reasons why it acted in accordance with the various constraints that limit its discretion.
I see that we have 5 minutes left before our time is up. Brandon, James, you want to just, I can't see how we're going to finish the slides in time. Is there a way that we can just highlight what the rest of the slides say and give Justice Laskin a moment to comment on them as well?
Yeah, I mean, Jamie, it might make sense to go to slide 12, where we set out the framework very briefly for reviewing decisions of the Canadian Transportation Agency, which I suspect would probably be the major tribunal of interest to members in the audience. So there are three main avenues of review for Canadian Transportation Agency decisions. One is a statutory appeal to the Federal Court of Appeal with leave that is restricted to questions of law and jurisdiction. That's under Section 41 of the Canadian Transportation Act. There is, and if you were to seek leave and get leave on that kind of appeal, then because it's limited to questions of law and jurisdiction, and it's a statutory appeal, the standard of review is necessarily correctness, because the court is applying the appellate standards of review, and those say questions of law review for correctness. The second type of review mechanism is an appeal to, it's really an ability to petition the federal cabinet or the governor and council to review and vary the decision. And that's also under Section 40 of the Canada Transportation Act. And that is, it's unlike the appeal route to the court in that it is nominally unrestricted. So it can extend to things that include questions of law and jurisdiction, but also matters of policy, discretion, fact, things that you wouldn't be able to appeal to the court under the appeal right. And then there's a third ability under the Federal Courts Act to seek judicial review to the Federal Court of Appeal itself from the Canadian Transportation Agency decision. Although there's a wrinkle here, and I think Justice Laskin may talk about this, in that Section 18.5 of the Federal Courts Act precludes you from seeking judicial review to the court to the extent that there is already an appeal right in another statute, as there is in the Canadian Transportation Agency, Canadian Transportation Act. So So those are the three main areas of ways to seek review. And I guess the fourth thing I would just say is, if you do bring a cabinet appeal under Section 40 of the Act, you can then seek judicial review from the cabinet decision itself to the federal court, not the Federal Court of Appeal, under the Federal Courts Act.
And Rael, I know we're short on time. I wonder if we might just put up the summary slide that summarizes all of this. This slide here.
Oh yeah, good idea.
Perfect. So just lastly, I'll let you speak to section 18.5.
Yeah, I was just going to say one thing about the Canadian Transportation Act and decisions under it, because I think perhaps for this industry, the most important element of Vavilov is that it requires correctness adjudication in the context of statutory appeals. Because our court, before Vavilov under Dunsmuir, our court reviewed questions of law and jurisdiction coming out of the agency on the basis of reasonableness. And that reasonableness gives the last word essentially to the tribunal. Our court has made it clear now that following Vavilov, questions of law and jurisdiction are to be reviewed on a correctness basis, which means, as a practical matter, that the court has the last decision, the last word. So I think the Vavilov decision has potentially some big implications for review of CTA decisions.
Very good. And the last point I just wanted to mention on this slide is that you may wonder, given the availability of the cabinet appeal and the scope of the cabinet appeal, which is essentially everything within the merits of an agency decision, what scope then is left for judicial review applications under Section 28(1)K, given the effect of Section 18.5 of the Federal Courts Act. And I think the effect of it is really to allow the prerogative writs that are still available under the Federal Courts Act to be brought by way of application to the Federal Court of Appeal. So, for instance, prohibition or procedendo if the agency was sitting on a decision for a very long time. Those kinds of things I think would still be available from the Federal Court of Appeal.
Justice Laskin, we'll give you the last word to you.
The last word. I think I've probably actually given you my last word already, Rael. But I encourage you to review the slides. I'm sure they'll be available to the group. They cover off some of the things that unfortunately we were not able to get to.
Thank you then. Justice Laskin, Brandon, Jamie, this has been a wonderful presentation. There was a lot to take in, and I think our group found it extremely helpful. We will be giving the slides to our technical person who we're hoping we'll be able to post it on our website at ctla.ca for those that want to have to see it in full. And other than that, if you want to either contact me or contact Jamie, we can email you our copy of the slides as well. Thank you all very much. Heather, back to you.
Well, thank you very much, Israel. That was absolutely fascinating. One of the things that I think is great about working in the transportation industry, besides meeting people like yourself and your panelists, is the variety of the work that we get. And judicial review is actually a very key aspect. And thank you to you and the panelists for bringing us very up to date on what could be complex, but was broken down into a very clear background. And that presentation will be very valuable for anyone doing a judicial review. Thank you.
Pleasure.
So